topic. So we have the next presentation by Sue-Marie Viljoen, Rent Control in South Africa.
Yes, hi, good afternoon, colleagues. And thank you again for the opportunity to discuss work that I've done specifically in my PhD a couple of years ago. So as mentioned in the title, I'm going to talk a bit about developments in South African law with regard to rent control. As you all probably know, and before I start, I should just say I don't have a PowerPoint. I'm not an economist, so I don't work with wonderful graphs and things like that I have to show you. So maybe you should. I'll just talk, and then hopefully you can follow me. So by way of introduction, as you all know, the statutory construction of rent control is generally understood as a measure that provides substantive tenure protection for tenants while also restricting rent increases. And this form of protection might seem attractive at first if one considers its aims. However, the criticism against the strict imposition of rent control is unassailable, which I will discuss briefly to highlight the need for a more flexible approach to rent regulation when appropriate. So a number of authors have convincingly argued that rent control statutes are futile if not combined with maintenance responsibilities of the landlord. Unsurprisingly, private landlords who are subject to rent control measures are more often than not looking for ways to drive tenants out of their buildings, for instance, by refusing to adhere to their maintenance responsibilities. Rent control therefore reduces levels of cooperation, as also alluded to by the previous speaker, between landlords and tenants, but arguably reduces levels of cooperation in society at large as well. Robert Elixin from the US argues that the effect of rent control is to lock landlords and tenants into a long-term, uncooperative relationship. Another indirect effect mentioned by Elixin is the negative impact that rent control could have on the labor market, since a tenant would choose to retain the benefits of controlled rent rather than to undertake a new job elsewhere. So this lock-in outcome has a negative effect on tenant mobility, which leads to other social concerns, including the accessibility of affordable rental accommodation for potential tenants. One of the major objections against rent control is the adverse effect that it has on local housing markets. As a lot of you would know, economists argue that by interfering with landlords' profits, rent control discourages new construction, it causes under-maintenance, and it often leads to more dilapidated buildings in areas where there are existing housing shortages. Rent control is therefore arguably counterintuitive, as it causes greater housing shortages. Richard Epstein, also from the US, has even argued that rent control amounts to an uncompensated taking. The United States Supreme Court disagreed and upheld the restriction on the right of landowners to evict tenants on expiration of the lease. Rent restrictions are therefore generally considered to be justified in light of prevailing socio-economic circumstances. So even though these arguments against rent control have been opposed on the basis that they are not substantiated, policymakers should be wary of implementing a strict rent control regime in light of the potential negative effects of rent control, and that would include the legislative complexity concerning rent control measures, the substantial administrative costs for the government, and the negative impact that this type of intervention could have on the housing markets in general. Governments are often inclined to avoid such a stringent form of statutory intervention in the private rental market, especially if the beneficiaries are limited to only a number of vulnerable tenants. So in the absence of rent control measures, and a clear underlying policy to that effect in South Africa, the South African Constitutional Court in Mafangu versus Angus Lifestyle Properties, this case was decided in 2012, the court here created the possibility for rental housing tribunals to strengthen the tenure rights of marginalized tenants to such an extent that their lawful occupation could be kept intact permanently or for a stipulated period. Ideally, this type of intervention should occur only in extraordinary circumstances, once the tribunal has weighed the interest of both parties and made a reasonable decision concerning termination and eviction on the basis of a proportionality test. So the essence of the majority judgment is centered on the tenant's initial complaint to the tribunal, namely that the landlord's action in terminating the lease constituted an unfair practice. In terms of the current act, the Rental Housing Act, the landlord has the right to terminate the lease in respect of rental housing property on grounds that do not constitute an unfair practice and are specified in the lease. So there are those two requirements as mentioned in the Act. In terms of another section, section 13.1, this section empowers any party to lodge a complaint with the tribunal concerning an unfair practice, and an unfair practice, importantly, is defined as a practice unreasonably prejudicing the rights or interests of either a tenant or a landlord. So the court made the distinction between interests and rights to include more than legal rights under the umbrella of tenants' welfare that could be affected by termination of the lease. These interests include all aspects that could have a negative impact on the tenant's well-being, including her home interests, security of tenure interests, and all other socioeconomic and personal interests. If the ground for termination of the lease contravenes any of these interests, the tenant should be able to argue that termination of the tenancy constitutes an unfair practice. If the tribunal agrees, termination of the lease would be set aside and the tenant would be able to continue occupying the premises as a lawful occupier. So in this judgment, the landlord's ground for termination was quite straightforward. It simply wanted to increase the rent beyond the escalation clauses. These provisions, the escalation clauses, were initially included in the contract to protect the tenants against unreasonable rent increases, and the owner tried to circumvent this purpose by means of cancellation, which prejudiced the tenant's housing and security interests. Arguably, the reason for termination of the lease did therefore constitute an unfair practice, and the court went along with this reasoning. So I'm going to quickly look at German law, and I hope I'm still correct when it comes to what is stated in the basic law or the civil code. So the German approach is noteworthy in this regard because the civil code restricts rents and ensures security of tenure for tenants, which is considered an integral part of landlord-tenant law without the strict imposition of rent control measures. So obviously rent control measures can be implemented in certain areas, in certain zones, in certain parts, in certain jurisdictions. But in general, in terms of the civil code, rent control is not strictly implemented, but there are these broader protective type of measures. The restrictions placed on the rights of landowners are not perceived as emergency statutory interventions, since the tenant protection measures are included in the civil code. So generally, the landlord or the tenant, in terms of German law, may terminate the lease, either fixed term or periodic, without giving notice of termination to the other party, provided that there is a compelling reason. A compelling reason is deemed to exist if either party cannot reasonably expect it to continue with the lease until the lease expires or until the end of the notice period. The tenant would generally also be able to terminate the lease where the property is in such a condition that it engenders her health, whereas either party can argue that there is a compelling reason to terminate the lease where the other party continuously disturbs the domestic peace. Now, in addition to those grounds, the Civil Code protects tenants who rent residential property for an indefinite period by providing that the lease may be cancelled only in accordance with the Civil Code and subordinate legislation. A lease for an indefinite period of time may be terminated by the landlord by giving notice, provided that she has a justified interest in terminating the lease. The tenant may object to the notice of termination and require continuation of the lease if the expiration thereof would cause a hardship to the tenant that is not justifiable, even when taking into account the justified interest of the landlord. Hardship suffered by the tenant includes where he is unable to find suitable alternative accommodation on reasonable terms. If the tenant's objection is successful, the lease continues for an appropriate period, taking into account all relevant circumstances. The terms of the original contract would then remain intact, except where the landlord cannot be reasonably expected to continue with the lease under the previous terms. In such a case, the terms may have to be amended. So when considering fixed-term tenancies, the point of departure is that the landlord must state a valid reason for entering into such a tenancy, and the reason must be in accordance with the Civil Code. If the initial reason for the fixed-term lease exists 4 months prior to termination of that period, the tenant may demand an extension of the lease for an equal period of time. However, if the initial justification for a fixed-term lease no longer exists, the tenant may demand an extension for an indefinite period. So arguably, the general grounds for termination of the lease, namely where there is a compelling reason or the landlord has a justified interest in cancelling, these are generally similar to the grounds for eviction in a number of rent control statutes. However, the grounds for termination that form part of the General Civil Code are not decisive because the tenant's defence on the basis of a hardship that he could suffer as a result of termination can override the landlord's interest in cancelling the lease. The hardship provision is arguably a mechanism that allows the court as the final decision maker to weigh the interests of both parties before granting termination of the lease. This provision incorporates some measure of context sensitivity, as the courts can consider the impact of termination on the specific tenant or his family and judge on the grounds of personal circumstances whether it would be just and equitable either to grant termination or not. So in South Africa, the Constitutional Court in Mafangu developed a similar flexible mechanism that enables the rental housing tribunals to provide substantive tenure protection for certain category of tenants in exceptional cases. According to the case, a tenant can approach a tribunal and argue that the ground for termination constitutes an unfair practice because the effect of termination would unreasonably prejudice the tenant's interests. This would typically be the case where termination and eviction would cause a disproportionate burden for the tenant, for example, if he would be rendered homeless. In such a case, the tribunal acts as the final decision maker and judges on the basis of fairness and equity, taking into account the specific circumstances of both parties. If the court finds in favor of the tenant and decides to provide some measure of tenure security, it should set aside termination of the lease. The effect would be to create a tenancy similar to statutory tenancies as developed in jurisdictions such as the US, the UK, and also pre-1994 South Africa. Although such a tenancy would not originate in legislation, as it is in terms of strict rent control regimes, it would rather originate in terms of the court decision or the tribunal decision. The terms and conditions of the contractual tenancy would remain intact, except if the landlord can show that it would not be just and equitable. The tribunal should have a wide discretion in determining the outcome of each case and aim to accommodate both parties. This does not mean that the landlord would be deprived of his right to terminate the lease. It simply means that the ground for termination would have to be lawful. The court's approach in Mafangu signifies a substantial transformation in the South African landlord-tenant regime because it empowers tribunals to grant substantive tenure protection. Tenants can approach these tribunals and hold landlords accountable for unfair practices, including exploitive rents, as well as grounds for termination that are unreasonable, and of course then also inadequate maintenance. A significant distinction between this approach and the protective measures included in rent control statutes is that the burden of proof rests with the tenant to approach the tribunal, and secondly, to convince the tribunal that the landlord's practices are in fact unfair. The tribunals are therefore enabled to provide protection for tenants on a case-by-case basis and strike a balance between the interests of the parties. However, at this stage, it remains unclear what interests the tribunals will in fact take into consideration and whether or not the tribunals are in fact able to adequately weigh the interests of the parties. Thank you very much. I am happy to answer any questions.
Yeah, thank you very much too. So I have one question, referring to your to the South African system that you just described. So imagine that I'm a tenant, and I find that the rent is overvalued. How can I prove it? What are the proofs that I can or have to provide to the tribunal?
I think one of the things that they currently use, and that has been used in the past as well, is simply to look at the market to determine what the market rent would be for that type of dwelling. Especially in the private market, it should be quite easy to determine what the general market rent would be for a dwelling of that kind. And I think on the basis of that, the tribunal should be able to determine whether it's excessive or not. They will most likely also look at escalation, to what extent the rent has escalated over the past couple of months or years, and then that would be used to determine whether those escalations are in fact on par, whether it resembles what is happening in the market or not.
So it means you raised a very important question, that of information, because it's not something granted. The availability of the information on rental prices, because in many countries you cannot find this information, or you can find, for example, only advertisement data, as is the case in Germany. And we also have this Mietspiegel system, which was mentioned, I think, by Christoph yesterday, which is literally translated into English would sound like rental mirror, but it's on the one hand it's under critique, and on the other hand it's very politicized instrument, and people try to so it's a kind of average prices, rental prices over a certain period, and then politicians try to increase the period that is taken into account. So in the beginning it was 4 years, now they want to do it, I think Christoph can correct me, they increased it to 8 years, and there are some suggestions, but maybe I'm wrong, there are some suggestions to increase this reference period to 10 or 20 years. So you imagine how far these values will be from the market.
Yes, how far do you actually have to go back to determine what is reasonable now, you know? Yes, I hear what you're saying. I think you can also, in South Africa, we have Stats SA, so there's a lot of information that we can get on statistic-wise what is happening in the market, housing prices, rental prices, those type of things. It's of course inevitable to keep that up to date and have that information accessible. But I think in general, the prices are escalating, most definitely depending on, area-wise. And how you keep that intact is always difficult. So yes, I think one of the main things is to look at escalation, but also to see then what's happening in the market generally, and then to determine whether there are not perhaps underlying reasons why rents are being escalated, whether the landlord would not actually just want to get rid of the tenant for other reasons. I think those are obvious things.
Is there any data about how widespread the system actually works in practice, that is implementation?
At the moment, we are struggling to get information on exactly what is happening in those tribunals. Obviously, when it comes to court cases, we can track those decisions, and we can see what exactly the court took into account when getting to decisions. But the tribunal's information is not as accessible as it is with regard to court decisions. And therefore, we are struggling to see how many cases are actually going to the tribunals, and what interests are being evaluated and weighed by the tribunals, and whether the system is actually efficient enough. It would actually be interesting to know how many people are approaching the tribunals to see whether the system is working, whether it's not perhaps overloaded, because if you have a lot of cases, the tribunals might be overloaded, as it often is with courts. So that information is something that we still need we need to get more data on exactly what is happening in those tribunals. And to some extent, it's a pity that we do not get the information as we would with court cases. I think a lot of information is then slipping through the cracks, if we can say it in that way.